Hi, it's Doug Isenberg, and the domain name dispute decision I'm talking about today involves a case filed by the Barack Obama Foundation against someone who had registered 7 domain names, each of which contained the Obama name plus the words Presidential Center or Presidential Library. At first glance, it might seem like this is a straightforward case of cyber squatting, and the Obama Foundation did receive a winning decision ordering transfer of all of the domain names, but the case was a bit complicated for a number of interesting issues. So this was a dispute under the UDRP, the Uniform Domain Name Dispute Resolution Policy, and the decision was issued by a 3-member panel at the forum in September 2021. I've included a link to the full decision in the description if you want to read all of the details that I can't cover here, since I'm just going to touch on the highlights of the case. So as I like to do in these UDRP case summaries, I'll begin with a very brief overview of the facts, which are as follows. The complaint was filed, as I've already said, by the Barack Obama Foundation, which is a nonprofit organization that, among other things, oversees the creation of the Barack Obama Presidential Center. President Obama, according to the decision, claimed common law trademark rights in the Obama and Barack Obama names, and he apparently relied only on those common law rights in the UDRP case. The 7 disputed domain names, which you can see here, were all created in 2008 and 2009, beginning shortly after Obama became a frontrunner for the Democratic Party until immediately after he was sworn in as president. Now, all of the domain names in this case, according to the decision, were used in connection with commercial pay-per-click or PPC websites. Since UDRP case files are not publicly available, I can't see exactly what the Obama Foundation submitted in its complaint, but here's a screenshot of one website using one of the domain names, the Barack Obama Presidential Library.com, that I captured shortly after the decision was published. As you can see, the PPC site includes links for a variety of topics unrelated to President Obama, but also one labeled Obama Healthcare, which obviously was a significant part of his presidency. Also, the Obama Foundation said that the registrant of the domain names had offered to sell 2 of them for $50,000 each. Now, the registrant of the domain names failed to submit a response by the deadline, but did submit one about a week late, which the panel accepted. Interestingly, he argued that the Obama Foundation was not an active organization in good standing, that it lacked status to file the UDRP complaint since it was not created until 2014, 5 years after the disputed domain names were created, that he intended to use the domain names for what the decision calls bipartisan speech forums, where he and others can exercise free speech around President Obama's legacy, and that he did not try to sell the domain names to the Obama Foundation. Each of the parties also submitted additional filings. So, what makes this case interesting? I think at least 6 things. First, any UDRP complaint filed by a former president of the United States is obviously unusual. President Clinton filed a UDRP complaint in 2009, which, by the way, he lost, and President Trump has filed quite a few UDRP complaints through the years, starting in 2001, but they were all on behalf of his private businesses and not in his capacity as a president or former president. Second, as I said before, Obama amazingly relied only on common law trademark rights in his name, apparently because he did not have any relevant trademark registrations when his foundation filed the UDRP complaint. As I've explained before, including in episode 5 of my masterclass on domain name disputes, the UDRP does not require that a complainant have a trademark registration, so common law rights are sufficient, but they can be difficult to establish, especially for personal names. But in this case, the UDRP panel said that Obama had obtained trademark rights in his name, not as a result of his role as president, but as the author of 2 New York Times best-selling books, Dreams from My Father and The Audacity of Hope, which have sold millions of copies. Now, interestingly, it looks like the Obama Foundation actually obtained a trademark registration for the Barack Obama Foundation just 3 days after it filed the UDRP complaint, which makes me wonder why they didn't wait to file the complaint, but ultimately it didn't matter. The third interesting aspect of this case, and one that doesn't arise too often, is that there was an issue as to whether the Obama Foundation, which is the entity that filed the UDRP complaint and not President Obama himself, actually had standing to bring the complaint. But after a brief discussion, the panel said that the foundation did have such rights, given the close relationship between Obama and the foundation. Fourth, and this is just a procedural issue, but it's interesting to see that the 3-member panel accepted the registrant's late response, as well as additional filings from both parties. Now, the UDRP rules give panels the power to conduct proceedings in such manner as it considers appropriate, and the panel here obviously wanted to make clear that it had considered all of the relevant issues and given the parties a full opportunity to argue their cases. But, as I always tell my clients, the UDRP process does not explicitly allow anything more than a complaint and a response, so you should never count on a panel accepting late or supplemental filings. Next, the fifth interesting thing I find in this decision is how the panel reacted to the respondent's argument that he was planning to develop free speech forums around the domain names. So here's just one part of what the panel wrote on that issue. Had respondent registered the domain names for a free speech forum, he would not have needed to register so many domain names, and the domain names would not refer to President Obama's presidential library. Panels have long held that unsubstantiated claims of future use do not confer any rights or legitimate interests upon respondents, and that non-use or warehousing of domain names does not prevent a finding of bad faith under the doctrine of passive holding. Now, I talk more about passive holding in another video where I discuss the landmark nuclear marshmallows case, and I've included a link to that video in the description here too. The sixth and final interesting issue here is the panel's discussion of what is referred to as opportunistic bad faith. Now, it's not one of the enumerated ways in which a trademark owner can establish bad faith, but it arises not infrequently. Specifically here, the panel had this to say. Complainant submits that respondent registered the domain names in bad faith because their registration was opportunistic, since the domain names were registered in anticipation of former President Barack Obama's political career. Complainant argues that respondent deliberately registered the domain names to capitalize off the value related to the eventual Obama Presidential Center. The panel sees merit in this argument and concludes the domain names were registered with opportunistic bad faith. So, as I said at the outset, this was an interesting case for a lot of reasons. And finally, one last thought. It will be interesting to see whether the Obama Foundation uses these domain names, perhaps to redirect users to the official website for the Obama Presidential Library, which, by the way, uses the domain name obamalibrary.gov. While we may see other cybersquatting activity related to the Obama Library, we shouldn't see any that use .gov domain names, which convey a sense of authenticity, since they're not generally available and instead are limited to certain government and publicly controlled entities. If you want to learn more about the UDRP, please check out my masterclass on domain name disputes, as well as other resources on my GigaLaw website. And be sure to subscribe to the GigaLaw YouTube channel to be notified of future videos discussing other UDRP cases. Thanks for watching, and see you next time online.